Very well, Jim.
I like your light display there.
Yeah.
Got my email. Yeah, exactly.
Oh, is there? He said they're all. Yeah.
So cool. I like your shirt. They come in men's clothes also or not?
I almost wore.
Purple's the color of loyalty.
Oh, is it? Okay. Very good.
I had a light
One of
color.
my favorite colors.
I had a light colored purple one with I almost wore that tonight.
I like the color of death.
Yeah.
Purple is used, yeah.
I had mini over Tuesday. Yesterday was the county over here. The day before I was
Probably nothing gets done.
I guess you can crank it up and it's about time. Oh, it's on already?
Oopsie. Edit.
Does he? You gotta warn us. We're talking shop over here. You guys all set?
Yep.
Ready? Okay, good evening, everyone. We're going to get started. Ask that you please stand for the Pledge of Allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
If you could remain standing for a moment of silence in memory of Pearl Harbor Day, for those who perished that day. Thank you. Okay, welcome to the December 7th, 2017 Town of Riverhead Planning Board meeting. We have several public hearings on the agenda tonight. I am going to go out of order and start with number 3 on the agenda, the AutoZone expansion. It's a very quick one, and it's the second time that they were here, and it shouldn't take more than a few minutes. I don't want to have them here for the other hearings. They may be here for a couple hours. So we'll start with the AutoZone expansion, public hearing on a site plan to construct an addition on an existing building on Route 58.
Good evening. My name is Heather Davis. I'm with Bergman Associates. We have contacted the abutters with certified return receipt mailings, also posted the signage in regards to the public hearing. I believe you still have the plans that we made additions to from last time. The other question that came up was irrigation for the current plantings. AutoZone does not have irrigation out there. In their scope, they don't believe that the yard is large enough to justify irrigation. However, the plantings that we're proposing there are more tolerant to the conditions that they will be in. Once they're put in the ground, the contractor will replace within a year. And then from there, the store manager will contact AutoZone with any plantings that die off after that. Knowing that it's a issue with Riverhead and we do want to keep it, looking nice, we'll be sure to, AutoZone will be sure to keep up with it from there on out.
Okay, we could get into those details when we have you back at a work session.
Okay.
But if you could, just briefly describe what the project is about, what you're looking to do.
Sure. It's an expansion of about, 1,500 square feet on an existing AutoZone building. It'll be for more parts storage. And we will also be updating the parking for the larger spaces as required by code. There will be some changes to the handicap accessible ramps on the sidewalk along Old Country Road as well. We're working with the county on those currently. So yeah, it's just basically an addition to the current building, all within the current setbacks.
That's going in on the east side of the existing building, correct?
Yes.
And the square footage?
I don't have it right in front of me, but I believe it's...
We have it.
15,
1,516 square foot addition on the east side.
Correct.
Okay, does anyone from the public want to address the board on this application? Please come up and just state your name for the record.
Good evening. My name is Marianne Mangles. I'm the administrator of Acadia Center for Nursing and Rehabilitation, the nursing home that is directly behind AutoZone off of Woodcrest, between Woodcrest and Harrison Avenue. And we did receive notice of the addition that AutoZone is preparing. And with all due respect to AutoZone, because we don't have anything against them, but we do have a concern regarding the possibility of increased traffic flow to the store, because we currently have a really bad problem with customers exiting AutoZone who need to go east on Route 58. It's because there's no traffic light on Woodcrest, which is their egress onto the street. People are coming through our parking lot at high speeds because they're treating it as a through street. And it is quite dangerous. There's at least 5-10 cars an hour coming out of there, and not just from AutoZone. There's another business next door to AutoZone that is some type of a security company that have a lot of cars, large SUVs, that come and go. And ideally, we would love to see a traffic light at Woodcrest so that the trucks coming out of AutoZone and the other place could comfortably, safely make left turns, plus the cars. And it is quite dangerous to do because of the traffic and the speed, and people aren't really observing the speed limit. So we understand why they want to come through our parking lot. But our parking lot is full of elderly people visiting their spouses and relatives, and people have to run out of the way because they're not stopping. And it's always been a problem, and we've even considered the possibility of coming to the town to ask if we can close the Woodcrest Avenue exit so that we could have a safe environment for our residents and our families. But if we even did that, I don't know what the traffic from AutoZone would do as far as increasing the number of car accidents on Route 58. So it's not that I'm coming here with a particular request or an objection against the project, but I really appeal to the planning board to look at what is going to happen and perhaps consider a traffic light, or maybe give them a curb cut on Route 58. So the traffic will make a left right out of there. That's all I really have to say.
Okay.
Okay.
I'm just trying to understand how cars who want to go to AutoZone would need to come off of Harrison or Woodcrest through the nursing home to get to AutoZone. When
No, it's when they're leaving. They
So they
pull
leave
in.
there.
Yeah, they pull in to Woodcrest because the entrance to AutoZone is on Woodcrest. Now they're pulling out. To make a left is not easy. It's extremely difficult, and you can sit at that corner
So they go
for
through and
several
go to the
minutes.
light.
So they back up, go through our parking lot, go down to Harrison. Harrison has a light. They can make a left turn. But they're using our parking lot as through street, and it's dangerous. And we've put signs up, this is private. It doesn't stop anybody. And when you have large trucks going through there, and they're going quite fast because they think of it as a street. So it has been a problem. We're afraid it's going to be even more a problem and people are going to get hurt.
Okay,
Okay.
thank you for your comments. Could someone move that easel, because it's kind of blocking the podium there. Heather, do you want to respond to that? Do you think there's going to be any increased traffic as a result of your expansion? Do you have a need specifically to store more parts because of the business, or are you going to be expanding, big trucks coming in and out of there, delivering to bulk suppliers or anything?
No, I think what it is it's just additional storage for, they'll ship some of these parts to other AutoZones and other locations. I don't think they're anticipating a huge increase in customers based on this additional square footage. It's more for just storing more parts that people typically come in for. They're running out of parts, and so this is just a way for them to add more of that. I wasn't aware that people were coming through your lot. I don't think AutoZone's aware of that either. There is a exit and entrance on Old Country Road, but you're forced to take a right out of there. You can't take a left out of that entrance.
And to try to take the left out of Woodcrest is the same problem.
I just did it today, so I totally understand that.
Okay. Anyone else want to address the board on this application?
Yeah, it's not necessarily for the public hearing tonight, but I disagree with AutoZone's handling of the landscaping and their future plans. Call and we'll take care of it. I'm not opposed to waterless landscaping. I'm all for it, but it's gonna have to be stones or something else. Grass and shrubs that don't get any water, I don't think that's gonna work.
Okay, I can take it back to them. That was their response to me. I let them know that the board, had some issues, with the
Yeah.
dying plants. The plants that I'm proposing in that site now are the ones that are living right now. It's the same variety.
It's not an attractive site.
Mhm.
I know some of the personnel over there. I've asked them over the years to kind of clean it up and make it look a little better. Nothing's ever been done.
Okay,
So we're gonna need to address it during the site plan issue.
okay, no problem.
Thank you.
So when we have you back at a work session, maybe someone from AutoZone can come too and
Yes,
hear it for themselves.
sure.
Okay, anyone else from the public or the board? Okay,
Make a motion to close the public hearing for Riverhead AutoZone. So moved.
Second.
okay, motion made and seconded to close the public hearing for AutoZone expansion. All in favor?
Aye.
Aye. Opposed? Public hearing is closed. Ms. Mangles, your comments are part of the record, and they will be considered by the board as we move forward. You're welcome. The next public hearing on the agenda is a minor subdivision for, Reeve minor subdivision, for a two-lot minor subdivision lot line modification.
May I use the easel?
Sure.
Yeah.
I assume the board has a copy of the map of the reference.
Greg, for the board.
Yeah. So after the. Good evening. My name is Martin Finnegan. I'm an attorney with Toomey, Latham, Shea, Kelly, Dubin, and Cordero, and I'm here for the applicants, J&S Reeve Summer Cottages and 18 Whites LLC, and their principals, the members of those entities, John and Sandy Reeve. This is an application, as you know, for a minor subdivision of the combined acreage of the parcels which are identified as, on the tax map, as 86-4, 16.7 and 16.9. The application is to divide them into two conforming lots in the RB 40 zoning district. This application enjoys significant support from the neighboring property owners, with the exception of two. The Andes family that lives directly to the west of the Reeves on White's Lane, and the Silvers, who actually live across Reeves Creek. Their counsel has submitted some correspondence to the board and asserting some grounds for their opposition, which I will address. I also have a letter that I would like to submit to the board, if I may, which addresses those comments. In addition, I have some copies of letters of support from neighbors. Would it be okay if I hand them?
Sure, you can give them to Greg.
As you may be aware from your review of the staff report, this property has a rather unusual history that I'd like to just briefly touch upon, if only to provide some context for the application. The two parcels that are part of this application were originally a single lot that was identified as Lot 16 on the tax map. Based on an interpretation of language in a certain deed that was from back in 1973, the town assessor's office asked the county to cut this up into that 16 into three different parcels back in around 1994. And that's the way the property was configured on the tax map at or about the time when the Reeves took title to the property. At some point in the future, they wanted to construct a dock off the property, and they were advised that they needed to have more frontage, so they applied for a lot line modification. That would be in 2007, to enlarge one of the strips of land that had been created by that division by about 1,200 square feet. The resulting lot that was approved after that lot line modification by the planning board is what is now known as Lot 16.9 on the survey, and that is the lot upon which the dock was constructed. So following the creation of that lot 16.9, the Reeves had applied for a building permit and were issued a building permit to construct a dock. They subsequently constructed a dock and were issued a certificate of occupancy for that dock. The Andes and the Silvers filed appeals to the Zoning Board of Appeals challenging the issuance of the certificate of occupancy. Their argument was, in essence, that the original division of Lot 16 was not done by the planning board. Therefore, the subsequent lot line modification moved a line that was not properly created, and therefore the whole thing fell apart. As a result of that, the lot line modification was declared a nullity, and eventually the certificate of occupancy was declared null and void. There were challenges back and forth regarding those determinations. The ZBA's determination was eventually upheld by the Supreme Court, and kind of brings us to where we are today. The town subsequently issued violations to the Reeves because, as a result of all this activity, they now have a dock on their property that does not have the benefit of a certificate of occupancy. But they want to keep the dock there for their personal use. And this application is submitted as a means to cure the pending violation and to properly divide what is now really back to that original Lot 16 into two conforming lots. So the nuts and bolts of the application are essentially that the Reeves are proposing that the entire, what amounts to about 111,000 square feet, 2.6 acres, that comprises lots 16.7 and 16.9, be subdivided into two lots that will meet the minimum requirements for lot size in the RB40 zoning district. If I may just... So, as you can see, and hopefully you have a little bit of it's not that large, but the proposed division line...
Why don't you bring it right up here to us and point it out, please?
Okay, sure. So, well, this is essentially the whole parcel of the dock that I just described is down here. Originally, it was all one parcel. This is the proposed line, which would create a conforming 1 acre parcel, and the remaining acreage would be in lot 2. This parcel, as you may be aware, is where the Reeves have their cottages. There are 6 seasonal cottages. There's their home. There's a barn, and all of these structures are CO'd. The cottage and the marina used down here are legally existing pre-existing non-conforming uses that COs have been recognized by the town. So the new lot is essentially, right now, not part really of this area, is not really used for any part of this operation, and all that would be proposed there is just the building envelope. Okay. So the subject property is serviced by the Riverhead Water District. There's an application for health department approval pending. The applicants understand that any approval here would be subject to approval by the health department, and any modifications or upgrades to the existing septic systems that the health department may require. An application for DEC approval is also pending. I believe it's been noticed in the environmental notice bulletin. I've submitted letters in support, that is, of the application from numerous neighbors, including Joanne and Vito Piche, Joseph Piche, Jim and Diane Klein, Jennifer Reeve, Mary Louise Ambrose, Diane and Sean McCabe, George Reeve, Fran and Charlotte Liebert, Paul and Katie Reeve, and Joseph and Donna Dorschka. Apologize if I'm saying that wrong to everybody here and my Polish mother. As mentioned previously, the only opposition to the application offered is by counsel for the Andes and the Silvers as part of their continued campaign almost against the Reeves. This has been an ongoing dispute between neighbors that I think has been described for you in your staff report. I don't think it's news to anybody here. There's been a lot of controversy, a lot of challenges back and forth between these neighbors. But they've raised some arguments to you in prior correspondence, and if I may, I would just like to take a minute to address some of those arguments. It will come as no surprise to you that the Reeves don't believe that any of them have any merit or any impact on this application. First of all, there was a suggestion that because there is some pending litigation regarding the marina use on the property, and that is a challenge by Mr. Andes to the pre-existing non-conforming marina use and whether or not that should be allowed to stand. The suggestion is because that's pending out there that you are somehow constrained from acting on this application. That is a claim that has been made. There's been no disposition. There is no stay imposed by any court, and it has no bearing on the application. So the Reeves are obviously vigorously defending that claim, and in the absence of any stay, I don't see any reason why you would not be allowed to proceed with your consideration of this subdivision. I'm not aware of any provision of the town code or the town law that they've referenced that requires you to not proceed with your review, simply because a claim was filed. There's also no impediment to your review stemming from the special use application that the Reeves filed back in 2009, as was suggested. That was never disposed of by the town board. At that time, the Reeves had given some consideration to reconfiguring the docks on the marina side of the property. And there was, again, some controversy with that, and eventually they just decided not to proceed with that. The application was abandoned. I don't believe that the town board needs to take any action with respect to that. They have not done anything with the docks. They're not intending currently to do anything with the docks, so it has no bearing on this matter. Again, they suggest that you can't approve the application because the dock is there, and the dock should be removed before you proceed with your review. We're here to pursue this approval in an effort to achieve compliance and once again legalize the dock. I mean, recalling that the dock was built with the benefit of a building permit and got a CO following an approval process. The decisions that came down, and the Reeves, for the purposes of this application, have conceded that they need to be here to seek this approval, and so there's no reason to remove the dock. We are here in good faith to try to remedy the violation that exists and be in a position to reapply for a certificate of occupancy. Just to be clear, the revocation of the CO for the dock was based on arguments by Mr. Andes and Mr. Silver that this lot was not properly divided by the planning board. So here we are. The intent of the application is simply to address that very argument that they raised and to seek a proper division of the property. The removal of the dock is not a prerequisite to your decision on this application. The town has given the Reeves the opportunity to achieve compliance by way of this application, and that's what they are seeking to do. The next argument is that the subdivision can't be approved without some form of variance relief. And Andes and Silver have, we believe, erroneously concluded that you can't consider the minor subdivision application because the division of this 2.6 acre parcel onto a 1 acre parcel and a 1.6 acre parcel would result in an increase in the degree of nonconformity of certain uses that would end up on the resulting or proposed lot 1. But just to review, all of those uses, that the currently existing uses, which include the 6 seasonal cottages, the barn, the shed, the Reeves home, first of all have COs. They're all legally existing, or COs or letters of pre-existing use. The planning staff report confirms that the lots are entirely conforming to the bulk schedule of the RB40 zoning district. And even with the reduction, the proposed reduction in the size of what would be lot 1, all of those existing structures cover only 10% of that lot once created, should you approve this, which is well below the allowable 15% in the RB40 zoning district for lot coverage. So, if we were talking about a situation where all of a sudden this change of size of the parcel was going to cause an increase in lot coverage that would exceed what is allowable under the bulk schedule, then possibly I could understand this argument, but that's not the case here. All these structures are quite small, so most of them are seasonal uses, as you know. So, while it may seem like there's a lot of structures there at first glance, their size and configuration is not at all offensive to the dimensional regulations in the town code. And the resulting lot sizes are actually more consistent with the lots in the surrounding community. I should note that there's no change proposed as a part of this application to any of the pre-existing non-conforming uses that would continue on what would be lot 1. And they all are essentially in that area. The area that is proposed to be subdivided off is not utilized for any of these uses. Whatever impact or intensity is associated with them is now and would still stay in that exact location once the subdivision were approved. So in practical and visual terms, there will be absolutely no intensification of the use. But even if there were a determination that somehow the granting of this would result in an intensification, there's a process for that in the code. The code does not prohibit that, so it would not preclude you from granting the application. In fact, the code allows it by a special permit process, so there would be a condition of seeking that under 301-222A of the town code. There's no need for a use variance. There's no need for an area variance as we see it. There would just be that next level of approval. Should there be a determination, which I don't believe there would be, that there is actually an intensification here. The Reeves are not trying to avoid site plan review, as was suggested. That's ridiculous. The very section of the code that council references in the letter to make this argument says that to the extent that there is a change that would implicate some type of site plan review, that process can't even commence until all other approvals are obtained. So we have to be here first before we can go on to the next stage. And I'm sure this planning board is well able to determine what type of site plan review, if any, would be needed and include that in a determination. And finally, the comments about the survey, which were that a boat rack and a trailer, mobile recreational vehicle trailer were not included, I think are just kind of silly. All structures on the property are on the survey. We're talking about a couple 6x6s that are in the ground to hold some kayaks and such. The trailer could be hooked up and rolled away today. It's a vehicle. It is not a structure. No other vehicles owned by the Reeves are on the survey. Should the board determine or feel that they would like to know where they are today, we could certainly make that change. But this is not something that is a defect or something that, again, would preclude your review. So putting all this aside, what we come back to is what is a very simple and straightforward application. Yes, there's a violation, and it's no secret that the subdivision, if approved, would allow the Reeves to come into compliance and to deal with that violation. Granting the application will result in the creation of 2 conforming lots in the zoning district that would be in keeping with the character of the lots in the surrounding community. The single-family residence proposed is entirely conforming to all setbacks. It's of a modest size, similar to all those that surround it. And the balance of the property is going to be continued to be used just as it has been. This has been a long road for the Reeves. They're requesting that you grant their application so they can reapply for the requisite approvals for the dock and put this ordeal behind them. So I'll be able to answer any questions the board may have.
I have one for our attorneys. We'll get to that after everyone else speaks. But the boats that are at the docks there, are there any pump-out facilities for those boats? And where does it go if they do?
Can I ask John to answer
Sure.
that question? Yeah.
John F. Reeve, Aquabog, 28 Whites Lane. Any boats that need pumping out that stay with us, either through renting cottages or neighbors that rent from us, they all use the Town of Riverhead pump out system. The boats come once or twice a week or more if needed by calling the VHF number. So we do have service by the Town of Riverhead.
Okay, thank you.
You're welcome.
Okay, anyone from the public wish to address the board on this application?
Good evening. My name's Lisa J. Ross. I'm with Essex, Hefner, Angel, D'Italia, and Pasca. And I'm here representing William and Eva Andes and Martin and Dale Silver. These are the neighbors who are most affected by this application. I first want to apologize. I didn't have any opportunity to review the response of the applicant's attorney, although he did ask for time to put in a response to our letters. I didn't receive it till right now. So I would like that the record be left open so that I have an opportunity to look at his comments in detail and put in a written submission. I would also like to object to the defective noticing of tonight's hearing. The applicant only owns 1 lot, which he's seeking to subdivide into 2. However, the town's notice states that it's a public hearing on a 2-lot minor subdivision lot line modification application, which seeks to modify the existing boundary lines between 2 properties and create 2 new parcels. That's not an accurate reflection of what this hearing actually is, and I would like to note that my objection. And with respect to the support letters that apparently were submitted and are in the file, I think it's obvious that the Reeves have a lot of friends in town and town hall. However, this is not a popularity contest, and the number of supporters isn't a consideration affecting the board's decision on the subdivision application, any more than Mr. Reeves' private association with the town or with the town attorney is. Rather, the subdivision application should be denied because it's an unlawful subdivision and the intensification of a non-conforming use, which requires site plan approval. As the survey shows, the property is already excessively developed with a large 2-story frame house, a 2-story barn, 6 commercial cottages, 3 we believe are rented yearly and 3 which are rented seasonally, approximately 14 commercial docks, and a commercial shell fishing operation. And all of this within a quiet residential neighborhood on a dead-end street. And as far as the mobile home goes, our understanding is that there's been a mobile home park there for many, many years, and it's rented out, which is why we brought it up as the fact we said that the survey didn't indicate that. And also that there's, I believe, 3 permanent kayak racks also that are on the southern part of the lot. And the applicant wants to subdivide the 2.5-acre property and have all of this excessive development concentrated on a 1.6-acre property. This is clearly a significant intensification of the non-conforming commercial uses. I don't know how anybody could look at it otherwise. The nonconformities involve both an already overdense residential cottage colony, which would become more dense if another residential lot is created within the same area, and also a marina that is already underserved according to current regulations in terms of parking and facilities, which would become even more underserved if some of the open areas that could otherwise be used for parking are set aside for yet another wholly separate use and another dock. Under Section 301-243A of the Town Zoning Code, subdivision of land may only be approved if all structures on the subdivided lots comply individually with the zoning code. Here, the structures on the proposed subdivided lots would not comply. Because the property is in the RB40 district, it only allows a density of 1 residence per 40,000 square feet. The proposed 1.6-acre lot, which would contain 7 dwellings, not counting the mobile home, does not comply with the code. In addition, increasing the non-conforming uses by intensifying them is a change that requires a special permit and a use variance. It may require area variances, and it triggers site plan review. And under the town code, a use variance will be required due to the loss of the pre-existing non-conforming status of the buildings and uses of the property under Section 301-222A. Despite what the applicant's attorney says, this is clearly not a simple matter that should be decided on a minor subdivision application. As we know, this board does not have the power to interpret the zoning code or grant variances that may be required. Only the town board and the ZBA can. The applicant appears to be segmenting the review process to avoid answering the tough questions how a site plan with sufficient parking and drainage could possibly be accommodated on a much smaller 1.6-acre lot. The town's own staff report recognized that putting all the existing development onto a smaller parcel and adding another residence to the proposed 1-acre parcel was excessive, and that it also appears to be prohibited by the Suffolk County Sanitary Code. As far as the illegal dock, in making its determination, the board should consider that the subject property has been in violation of the town code since May 2014. It's 3.5 years have gone by. The dock has no permits and no certificates of occupancy. And despite this fact, the applicant has refused to remove the dock, which is located only 10 feet from the Andes property line, and is actively being used by the applicant's tenants and guests to launch canoes and kayaks, despite the lack of a certificate of occupancy. It's not being used for the Reeves' personal use. It's being used as part of the commercial use. As noted in the staff report, after receiving a code violation for the dock in August 2016 and refusing to remove the dock for more than 3.5 years, the applicant is now attempting to use this subdivision application as a means of keeping the dock and adding yet another residence to an already overcrowded area. For these reasons, the subdivision application should be denied. And we ask if you do not deny it outright, it should be held off, not because you're restrained or constrained from doing it, but because there is a pending Article 78 proceeding to invalidate a certificate of occupancy for the premises, which we believe should be decided because it has to do with what the non-conforming uses are on the property. And our understanding is that there was presently a special use application before the board. Now, it's been represented that's been abandoned. I would ask that it be withdrawn if, in fact, that's the case, because to my understanding, it's still out there before the board. Also, I wanted the board to be aware that the Andes and Silvers have recently commenced a Town Law Section 268 action against the applicant for removal of the dock after this 3.5-year period. So we ask that the court, we ask that the board wait until the Article 78 petition is decided, the special use application is withdrawn, and the dock, which is in violation and has been for 3.5 years, is removed. We also ask that the board obtain the opinion of special counsel that was appointed as to the necessity of coordinated site plan review and the involvement of the town board and the ZBA due to the intensification and of the non-conforming uses on the property. Anyone have any questions?
I do have a couple questions for our council, but one question for you, Ms. Ross. You mentioned about the notice was not accurate.
Yes.
Did you and your client understand what the applicant was proposing when you came here tonight?
Well, I would have to ask my client if he understood. I understood that this was not what was being proposed. My understanding was this is one lot that was being subdivided into two.
Right, but you understood exactly what they were doing, but you referenced that the notice was incorrect, so your understanding...
Because I feel the public does not know. I mean,
But I asked if you understood.
Yeah, I have more of an understanding of it because I'm clearly involved in it. I
Okay.
know what the application is.
Okay, thank you.
All right, thank you.
Any other questions? Anyone else from the public want to address the board on this application? It was pulled.
Just briefly to respond to a few of the comments, I think a lot of them were already brought up in correspondence and responded to, so I won't belabor them, but, yeah, I mean, we understand that based on decisions that the configuration of these parcels as they currently appear on the tax map as 2 lots, as they are currently taxed by the town as 2 separate parcels, was declared to be a nullity. And I don't think we've tried to hide the fact, and the application, yes, acknowledges that we have now 1 parcel, I've said that we're gonna subdivide, or seeking to subdivide. So, you know, the notice was, the application was filed, the notice was filed as directed by the town. I don't believe that there's any defect in that. I think it's pretty clear what's trying to be accomplished. With respect to the density issue, again, the number of structures, I don't believe, is determinative here. The town code, the bulk schedule dictates what can be on a property in this zoning district. And we have, yes, legally pre-existing non-conforming structures that are there, all have COs, and they're not covering more than 10% of this lot when they could cover 15%. I just don't understand mathematically why this automatically is an intensification of the use. So we don't agree with that interpretation.
Question, sir. I know the southwest lot at years ago was a garden. Is that lot being used now to support the marina and the other parking, or is it mainly being used to support the marina and cottages, or is it mostly unused?
Southwest lot?
The lot you're subdividing, the smaller lot, we'll call it, the lot with no dwellings on it.
It's a right of way. No, the Reeves house is right in front of that. It's right there.
So it's
and
not being
part
used
of the.
for
It's not part of the
support
marina
uses
use.
now? Okay.
You want- I'll have John testify.
Yeah, that's fine, thank you. I'm not sure if I'm getting my question right, but I'm trying to find out if you're using the southwestern lot, I guess we call it,
Okay,
to support the bigger lot.
this particular parcel that we want to take off the big parcel is garden right now, or was, in green grass. It's going to stay garden, except for a proposed house down the road, a small cottage. It's never been used for anything other than lawn and, you know, flowers.
That was my question, thank you.
Mr. Reeve, how many years have those cottages been there?
Cottages were built in 1948 by Washington White, and then it was run by Ben White, and we bought it from Benjamin. And to clarify an issue of the RV, that has not always been there. We've had 2 of them. They're 35-foot fifth-wheel campers. And then my personal thing, I can park them anywhere on my property I want. There's no town code says I can't put them in the middle of my lawn and store it there. So I put it where you can't see it, so it's out of sight. And it's covered up right now. It's always been covered up pretty much, I'm gonna guess 6 months, 7 months of the year with shrink wrap. So, okay, thank you.
We will certainly withdraw the special use application if you feel that's necessary. It hasn't been even thought of since 2009 or soon thereafter, so that's not an issue. With respect to the comments in the staff report about health department and sanitary, we have an application pending with the health department. They are reviewing it, and as I said, we understand that they could require some upgrades. We understand that any approval you would give would be subject to that approval. So that's not a reason for you to not act. It could be a condition of your approval, and we understand that. This is a really large parcel in the middle of a neighborhood that has smaller parcels. And as I said, when this subdivision would be completed, we're still creating parcels that are larger than most in the area and consistent with the size of the parcels there. So the addition of a small home is not, that's the only change that is even contemplated on this property. And we just don't believe that would constitute an intensification. So as to the requirement of a use variance, council had referenced a case in their submission that comes out of the town of Babylon, and that's a town code that has a percentage limitation on expansion of non-conforming uses. And there was a determination there that because what was contemplated exceeded 25% and the code limited that, then that would kick it into the requirement of a use variance. That's not the Riverhead Town Code. They are not prohibited. There is no limitation percentage-wise on the expansion of a non-conforming use. Even if we would get to that inquiry, there's a provision for that. It is allowed under the town code. So with that, I would, again, renew my request that the board grant the application. Should you require any further information from myself and from the Reeves, we would be happy to comply.
Okay, thank you. So, a couple questions for council. I'm not sure if Mr. Ehlers or Mr. Eisler would answer. The litigation that was referenced by Mr. Finnegan and Ms. Ross suggested, Mr. Finnegan suggested that we could act on it while that's pending. Would you agree with that as accurate?
I'll answer that, Mr. Chairman, for me.
Please.
I'm handling that case for the town and representing the...
Just your name for the record,
Oh, I'm
please.
sorry, Frank Eisler. I represent special counsel for the town. Smith, Finkelstein, Lumberg, Eisler, and Yakubowski is my law firm, 456 Griffin Avenue here in town. As I was saying, we're special counsel in the litigation representing actually the zoning board is the respondent, town respondent in that case. And there is no stay in effect that would preclude you from acting. The issue that's before the court is a review of the zoning board decision that found that the permits and the use of these different cottages and marina uses were valid, and either because of nonconformity or other factors. That decision is being reviewed by the court. It's fully submitted to the court. and at some point, there'll be a decision from the court. But in the interim, there's no legal impediment that I'm aware of in the court process that would stop you from proceeding with this application.
And also, Ms. Ross had suggested that variance are required, and it's outside the authority of this board to act. I mean, is that accurate, or?
Well, the planning board does not have the authority to grant variances. You have to deal with the lay of the land as it sits before you and in respect to the zoning code requirements. If there were a need for relief from another board, you could conditionally approve or you could deny for other reasons, but you would have to get, if there were a need for a variance, you couldn't grant it. It would have to go to the town board or to the zoning board.
I understand that,
Right.
but for the applications in front of this board now, there's, in your opinion, there's no variance that are needed for us to act on what's in front of us. That's really my specific question.
Well, in answering that question, I'd probably respectfully ask that we research it more and
Okay.
confer with the board. And it's a matter of litigation and giving you legal counsel. I'd rather not give you that opinion standing here without having really reviewed all the arguments of the
That's fine.
parties at this point.
That's fine. That's all I had. You guys, board have any questions? I'm going to ask the public first.
I was going to make a motion that we close the public portion, leave the written open for 10 days.
Let me just, thank you, Mr. Iceland.
Thank you.
Anyone else from the public want to address the board on this application? Anyone else?
Make a motion that we close the public hearing portion of the minor subdivision for Reeves. We're going to leave the written portion open for 10 days so council can respond, and so moved.
Second. Okay, motion made and seconded to close the public hearing portion and leave the comments open for 10 days. All in favor?
Aye.
Aye. Opposed?
I have a question. Is 10 days enough
Well, that would be for,
The young lady,
for
Ms.
council?
Ross?
Is 10 days enough to respond?
I would prefer a longer period if I could possibly have it, only because I only just received it. I haven't even had a chance to really look at it.
well, we voted already, so everybody said yes.
Yeah.
I'm not gonna, I heard at least 4 yeses in the question, so.
So that's my only question, 10 days.
Okay.
I was thinking really frank more than anything else.
Well, we, at the end of the comment period, you know, that's not necessarily when we're gonna make a decision. We'll contemplate it afterwards, because I assume we're gonna get more comments during that time. And then we'll contemplate those comments, and we'll have, you know, council advise us accordingly on the question that he asked for more time for.
Once the record's closed, after the submissions are made within your 10-day period, then
Right.
the board will have an opportunity to deliberate and investigate any legal issues.
Okay, so are you opposed, or? Okay, so it's as proposed. The public portion is closed and will remain open for written for 10 days. Thank you. Okay, next public hearing on the agenda is number 2, Great Rock Clubhouse Addition. Construct a 2-story clubhouse addition to the golf course on 15 Fairway Drive, Wading River.
Good evening, Michael Cox. I'm an attorney for Great Rock Country Club and Fairway Drive Holdings, the fee owner of the real property up there. As you may know, this site plan application, or a derivative thereof, stems from this top. Dick Kuzanaski's bringing up the affidavit of mailing the application and posting this year. The site plan application before you was first commenced circa 2010. Since then, a number of items have occurred at the golf course, including the ultimate disposition from the owners who initially filed that application to where we stand today. The current owners acquired the property at a distressed debt sale. The property was in foreclosure and significant financial struggles, and it was a purchase thereafter. That being said, what's before you is a 6,000 square foot from a footprint standpoint expansion of the existing clubhouse. Much of this was derived from being able to take the outdoor activities that occur on the existing patio on the property and bringing them inside. This was partially driven by noise issues that were raised in 2010, 2011, and 2012, and certainly before the current ownership that presently owns the golf course took title to it. As part of that, what's looking to be accomplished with this site plan is multifaceted. The first being that there is a approximately 6,000 square foot basement proposed for the expansion of the clubhouse. And the reason for that is the existing cart barn on the property is not large enough to support all of the golf carts that go out on the course regularly, as well as the maintenance equipment that is used to keep the golf course in the shape that it is today. What we propose is moving the actual golf carts from the current cart barn, putting them into this new expanded area underneath at a grade level, and then using the existing cart barn area as a maintenance area and removing some what's been deemed unsightly maintenance trailers from the property and turning that into an area to store those items. The second part of it is on the second floor of the proposed expansion, which is approximately 6,500 square feet in space, which mimics much of the existing patio on the property, is to take what currently happens at outdoor events, which are undertaken under a tent. The tent, we have a temporary permit which we file for each year, which stems approximately 180 days, is to take the activities that occur underneath the tent on the patio and bring them indoors. One is for noise purposes. Two, it allows us to provide more amenities in terms of the offerings that the golf course can provide for those events, and being inside to allow the golf course to stay competitive with the other golf courses in the area. As you may or may not know, golf overall has been on quite the decline. So anywhere there is able to kind of grab some extra margin in terms of sales at the place, including things that can't be done outside, that can be done inside, is what's looking to be done. That's pretty much the expansion. The expansion is going to occur in an area that is already disturbed. There is very, very little new impervious area that will result from it. The only impervious area really that will be increased is a slight increase in parking. Beyond that, the site is designed basically to replace the tent area, which has been subject to prior litigation. That's pretty much the extent of.
So what type of functions do you foresee in this 6,500 square foot addition?
So the golf course regularly hosts golf outings, and as part of that, the golf outings are typically held underneath the tent. The idea is for the golf outings and ancillary events like that to then be moved from the patio area into an indoor facility.
The restaurant, it's open year-round?
The restaurant is open year-round, yes, as is the golf course.
Okay. Any other questions from the board or the public? Okay, anyone from the public wish to address the board on this application, please come up to the podium and state your name.
Good evening. Sid Bale, President of the Wading River Civic Association. I attended the October hearing on Great Rock, and one of the messages that came out of it, I think it came from the consultant from Great Rock, is that it had a long backstory. And I was trying to think when this all began, and I can remember back around 1990 when a developer from Miller Place by the name of Bill Hine was going to build homes He was going to build about 220 homes on 1-acre parcels. And that was the zoning. And then the property changed hand, and there was to be a cluster development. And then the open space portion of it, the owners of the property, the new owners, use a provision that was available in the town code at that time for an overlay district. I think it was called a recreational overlay district. And then came the golf course. But since its creation, there have been a number of controversies. I was trying to figure it out. There have been at least 3 lawsuits that I can recall connected, with the golf course. And but the consultant in October, at the October meeting, is saying the purpose was to help eliminate some of these controversies and try to capture all of the anomalies of the golf course. Those are the worthy goals. However, I do have some concerns. I'd just like to briefly express them. I'm not convinced, but one of the things that was talked about quite a bit during the October hearing, I think Mr. Bregman talked about the staff recommendations. And it talked about one of the concerns was catering, okay, and limiting to golf events. And the consultant for the applicant said, oh, yes, we know that's in the covenants, and also the stipulations, the famous stipulations. Somewhere around 2008 or 2009, the town and the applicants, the owners of the golf course at that time, had a stipulation of settlements. And one of the issues that was causing some consternation, or a lot of consternation with the neighbors, were catering events and things that were too many, they were too loud, and as the attorney described, they were outdoor events under a tent. And some people said that they were inappropriate, some of these events that were being held. Now, if you look at the covenants, it's not highly descriptive. It just basically, and the stipulation that they should be golf events. But what is a golf event? All right. There was a back and forth between the ownership of the golf course and the town over the years over kind of like defining that. And at one time, 2008, 2009, 2010, apparently, the golf course was turning in a list of events to, I'm not sure whether it was the town attorney's office, et cetera, about what kind of events were taking place. And occasionally, apparently, some events that took place weren't reported, and that was probably just an oversight. But there was a difference of opinion about what a golf event was and whether or not the owners were in compliance. And if you bear with me, I just want to read a paragraph or so from a letter from the town attorney written in August 20th on 2009 to the attorney who represented the law firm at the time. The attorney's name is Mr. Chiarelli, you might remember him. Okay, and this is Dawn Thomas in her letter to him. As we discussed in our follow-up telephone call, the town declines to accept Great Rock's position that all member events are golf-related events and thus permitted. Specifically, the updated event lists includes 5 items entitled Members Annual Wine Festival. Such member events are not golf-related events which could be held at the Great Rock facility. Furthermore, golf club memberships or associate memberships sold for the primary purpose of allowing a catered event to take place at the premises would not be considered to be golf-related and would therefore be rejected by the town as non-compliant with the stipulation of settlement. Golf-related events must have a relationship to the golf course use, such as golf outings or tournaments. Should we observe events that are not golf-related, we will have no alternative but to determine the stipulation to be violated and proceed accordingly. I think Mr. Bregman mentioned... Bergman? Bergman. Okay, sorry. Okay. Mentioned something about the difficulty of, how this would be monitored. And I think that's really, really crucial. Now, I know there's a new ownership group, and I guess we have high hopes for this new ownership group. But that was a big bone of contention with the folks who lived around the course right now. Are there any people here who live around the course? Okay. It was a big bone of contention, made their lives miserable, all right? And to merely say, okay, stick to golf events, and it's, what you should do, okay, isn't going to solve the problem. It didn't solve the problem in 2009, 2010, 2011, 2012. And what's the definition of insanity, right? Keep doing the same thing over and over again, expecting better results. So that is a concern, and I don't have the magic solution, but I'm sure the town and the owners are capable of coming up with something that is a clearer, more precise definition. And the idea is, you got the impression that the previous owner said, well, we have to do A and we have to do B. If we don't do this, we're not going to survive. It's a dog-eat-dog out there in the golf world, okay? There's so much competition. Well, there's a little bit less competition in our area right now. We know the Calverton facility no longer exists. The Tallgrass facility no longer exists. So it's not a perfect golf world, but the arguments that they have to do certain things in order to survive, I think sometimes can be really stretched. So golf events have to be made clear. There have to be a system of reporting. There has to be a system of monitoring. So if some of the neighbors have a problem, they can, there is some record that they can have access to, and this can be controlled better. Now, a second concern, there was talks about buffering the new facility, even though it's going to be indoors, from the nearest houses. One of the suggestions, I guess, I'm not sure, I guess it's on the site plan, was a row of white pines to buffer, I guess, the sound. Now, if we were buffering a solar farm, a row of white pines might be a good solution. But if we're concerned about noise, it doesn't seem like to be an adequate solution. And I know in the October hearing, I think the Cider House group was here, and you were very concerned about controlling like outside noise. So, and I know that would be a real concern for the residents.
Sid?
Yes.
Just a quick question. I thought the reason to go from the tent into a building was to eliminate the noise for the neighbors.
Do you think there's going to be no noise?
Oh,
No.
The noise was the issue with the tent.
Exactly. No, I agree with you. Okay. One last question. Just one of the issues I raised. I brought a document with me in the October meeting that was prepared in 2012 by the then planning director, Rick Hanley. And it was his analysis of the history and the property, and he described the golf course as a pre-existing non-conforming use because of the introduction of the RB 80 zoning district, et cetera. And it had implications. In his document, it said, in that case, the decision should be before the town board, not the planning board, under this. I'd asked some questions about it, and the planning department apparently looked into it and got an opinion from Brad Hammond on it, and it differs from Mr. Hanley's opinion, and it says that it's a pre-existing conforming use, et cetera, and the planning board is the proper, I guess, venue. I have a question, and you don't have to answer it right now. If, from what was said here, this old application that was renewed in January, was being reviewed in January by the planning department. When they were reviewing it, what was the standard that they were using? Were they using the Hanley standard? Excuse me. It seems, because, I don't think it was repealed. There was no court ruling against it. There was no ZBA determination against it. Why didn't it any longer apply to the situation? I'm not disputing, what the work that Brad Hammond did, but it's a little bit puzzling, how that all came about. Okay, that's all I have to say.
Okay,
Thank you.
Thank you. Okay, anyone else from the public? Just state your name for the record, please.
My name is Jean Marie Kraus. I'm on Fairway Drive, and I was one of the original residents that sued. It was a long road. We thought we won, and this was done, and I can't believe we're revisiting this expansion again. We've already had problems. This past May be an example where they were having a graduation party, and we had to call and complain about the music was out of hand, and I was given a gift certificate to make it all better. Quite honestly, I won't be bought. I worked very hard for my house. I worked very hard all these years to pay for it, and I don't want it devalued. I know what the people that butt up against Vineyard 48 went through, and that's what I fear that our residents will go through if this is allowed to expand, because first we're going to start with just having golf events, and before you know it, we're going to be back down that road with catered events where we've got the drunks in the parking lot doing, I won't say out loud what they're doing, you could use your imagination, what we went through. We have the traffic, we've got them blowing through the stop signs when people are trying to drive through from the residents. It's just uncalled for. If they can't make it as a golf course, they should not try to put the fear into the residents that it's going to be our fault if they're not allowed to expand and make a profit. And don't tell me it's golf events when we're getting flyers in our mailboxes so that they can go and pack the place for a party. That's not golf events. And it shouldn't be my problem or the rest of the residents' problems that my home is devalued now, so when we go to sell, we can't get outpriced. We had several neighbors last year that sold as much as $60,000 undervalued from the rest of the marketplace because people, as they were looking at the houses, says, oh, well, we know all about the whole Great Rock story. So this is going on still, and it is our fear that when we do go to sell, whether it's next year or we wait until we're ready to retire to do it, that our homes are going to be devalued. Now, I have the covenants that clearly stated when I bought that this was not allowed. They were not allowed catering. They were not allowed to even put the restaurant in back then. I would not have bought into this development if they were going to be allowed to just break the rules and disregard the covenants and do what they wanted. So I do request that you take into consideration what the residents' fears are and not just the golf course needs to expand and make a profit. Thank you.
Thank you.
Ray Senzak, 52 Fairway Drive. I live with Jean Marie. I've been with her 14 years. I also have another residence in Wading River. I've been a 20-year residence in Wading River. My concern about the golf course is I went through cancer 6 years ago, and I remember back then stating to our town supervisor how I was worried about if something happened to me, what would happen to the value of the home, and whether Jean Marie would be able to sell it with that golf course creating the nuisance that it did. Now, as I see these things on Vineyard 48 and stuff like that, I only see that this golf course is headed towards catering. It is not just golf related. During the summer, I complained about one event. I was told by the town attorney to call him. I did not want to call him because it was new owners. When I went over, I talked to them on the phone. They sent a representative over, and he gave a gift certificate, which we gave to charity. Now, I believe that 140 houses around that golf course should live in tranquility. There are 2 roads going in and out of that road. One in, one out. When they expand the parking, what they're going to do is they're going to increase the volume of people coming into the neighborhood. It's not out on 25, it's not out on Sound Avenue, and it's not out on 58. What's going to happen is people are going to spill over into the neighborhood. We could have crime, we could have all kinds of things. I videotaped at 9:06 the last event they had with music. I came in from work and I went over and I videotaped it happening. And also, as Jean Marie stated, they had this event that I complained about, and it was a graduation party. And it was loud, and things happened. So I urge you to stay with the covenants, and please consider the neighbors. Their values of the home, 4 homes in that neighborhood have gone down in value. And one I know sold for under $60,000 below the market rate. And the one next door to it, or across the street from it, sold for a lot more. But I know that they wanted to get out. And also, I think my neighbor Dominique Mendez, who is president of the Neighborhood Preservation Coalition, she fought hard for that golf course not to expand any farther than it did. And frankly, it was really nice when that golf course wasn't around. And I thought maybe these new owners would be nice and quiet. They were given a restaurant, which was put in. And I believe that restaurant should stay the way it is. And in fact, they're going to have an event for New Year's Eve. Okay, that's fine, but it's something that I think that originally that golf course wasn't supposed to have. So I just wanted to say, please, I urge you to help the residents. And I also think that there may be some residents that may speak up and say, oh, it's nice to have a golf course. Well, it's nice to have a golf course, but not a catering hall in your backyard or in your front yard. And we already have east winds down the way. And what's going to happen is they'll just take an inch and then another inch. And I hope that's not going to happen, because those neighbors that will say, well, I think it's nice to have a golf course with a catering hall. Later on, when it becomes a Vineyard 48 situation, they're going to come back at the town. They're not going to come back to the golf course. They're going to come back at the town. They're going to say, hey, this is wrong. And the town will say, well, you were for it back then. And that's where it's at now. So I urge you, please help us. Thank you very much for your time.
Thank you.
I appreciate your service.
My name is Josephine Mikowski. I recently bought on Fairway. I've been a resident of Wading River since 1987. My parents owned since
49. Wading River has been growing, and we are concerned about all these changes. What I'm very concerned with, I happen to be on the outskirts of the golf course. So I got served papers about this event, planning. But there are a lot of our neighbors who never got notified. And they don't even, some things get posted on a tree, then they disappear, no one sees them. So I really would like this to be held off on so we can speak to other neighbors. Other thing is the transparency of what was in all of those old papers, what's going on. I mean, I happened to golf the golf course probably about 4 years ago. It's a nice golf course. The events outside, they are very loud, and I'm far back, so we do hear them. Hearing about other people seeing drunks and people doing things on people back lawns, it's not good. So I think that there's a lot more to look at. I also am concerned about when you come in Fairway, there's some properties that are for sale. What's going to go there and how that's going to affect the golf course, the in and out, the safety of the neighbors. We have a lot of people that take walks in the neighborhood, older people. I'm afraid of them having someone drunk come out of that street and getting hit by a car. So there's a lot of things to look at. And as I said, not that we want them to go out of business, but we want it to be safe for the neighborhood. So, and it is getting really, really busy on sound, too, as everyone knows, all the way down. Every weekend, we see that. So it's not just there, but I think that this has to be looked at a little bit closer. Thank you.
Thank you.
Hello, my name is Ellen McWilliams. I've been a resident of Great Rock since 2003. And my husband and I, my deceased husband, we loved it. We bought into that neighborhood because of the golf course. My husband volunteered there. He loved it. We've had a wonderful relationship. I feel that it did nothing but increase the value, having this beautiful, anybody that would visit us would say, oh, you live in such a beautiful neighborhood. You have this beautiful golf course. And the opening, that's taken care of by the people at the golf course, that's another asset that we do have, okay? We have East Winds across the street that does nothing but catering. I mean, they just keep opening up more and more restaurants. I don't see any drunks wandering around East Winds, okay? I don't see any drunks, and I go to the restaurant in the evening. I never see drunks, okay? So I don't know where that's coming from. But all I know is back in 2009, when they made this big hoopla about, when they wanted to expand and whatnot, the place went bankrupt, okay? Nobody was taking care of it. And then what happens? What happens to that property? Okay? My husband and I have a cabin up in Maine that was on a golf course, and the golf course went out of business because the business couldn't thrive. And guess what? The value of that cabin is down the tubes now, okay? So I don't understand where any of this is coming from. I do have a lot of my neighbors that love it. They just didn't show up tonight. So I think, you should get the overall feel, but, nothing stays the same, okay? Especially the golf industry. I don't know, since Tiger Woods, I don't know what happened, but it's just, it's a whole different thing, so they do. All right, so how come East Winds, I never hear any sound over there, okay? I hear, in my neighborhood, there's been graduation parties where the police have been called, all right? So things happen, all right? You don't remember when the police were called for a party in that neighborhood?
You just address the board, please.
But, so I'm here to advocate for, they've been they're going out of their way, trying to be, you know, good neighbors to us. And I think, I think basically the problem is noise, okay? So, you know, in order for them to survive, though, I do believe that they have to expand. And as long as it's, you know, within that perimeter where the tent was, and we're gonna get a soundproof room, I don't understand why there's so much objection. So, good luck.
Okay, thank you.
Good evening. My first name is Adrian, my last name's Hark. I live in Wading River for about 30 years, multiple places. I have a bachelor's degree in economics from Stony Brook, and I'd like to shed a little light on what might be going on here. We have a situation where the golf industry is not doing as well as it had in the past. Might be doing well in the future, we don't know. That's the current market situation for the golf market. Now you have a company that came in and bought a distressed asset, in this case, looking to make a turnaround, is seeing a situation where it's struggling and could possibly grab revenue in another source, like a catering, you know, thing. The proof is always in the numbers. The site plan submitted a 6,000 square foot footprint, which I believe includes a basement and two stories? 2 stories and an additional 500 square feet on the second story for a total of 18,500 square feet total usable area building. Doesn't sound like that's for golf outings. That sounds like that's for catering, which you know, that might be fine, you know, up to the planning board, but, you know, what's the saying? If it walks like a duck, talks like a duck, quacks like a duck, it's a duck. And it's 18,000 square feet of usable space. As a resident, my only concern there would be the traffic coming in and out of Fairway Drive, because you have the Eastwind Catering facility right across the street. You have their shops that they just recently opened, and now you want to increase, even if it's not a catering, just golf, you're increasing traffic by the means of adding 18,500 square feet of commercial space. That sort of situation should be walked back a little bit and taken a little time to understand what's going on. When you have I guess in the layman's terms, you have a business across the street that might be doing better than the business that you bought into, and you can see a avenue at which you could kind of move in on it, that could cause rust of some others people that live by who've seen it always been a certain way, and now you're looking to change it solely for a profit margin. You know what I mean? And everything's not dollars and cents, but in a lot of ways it is. And this seems to me like the true intention here is to expand profit margins, and then at the expense of the people that might live surrounding it, by pulling the wool over their eyes and saying, oh, it's this, it's not this, it's this, it's not this. You know, the old 3-card Monty, you know what I mean? Follow the ball. When you go, if we change it enough, you'll forget what it really was. But the proof is in the numbers. You're adding 18,500 square feet building, limited parking space to a building that size, and you're saying that that it's not going to have an effect. It will. It is. Thank you very much.
Thank you.
Hi, good evening. My name's Sue Nectel. I'm a resident of Deer Run, not directly in the Fairway community, but the surrounding block, and we have 2 areas of our cul-de-sac that border the golf property. I concur with my neighbors, the concern with the quality of life, sounds, the increasing building in general in the Wading River area. We've got the shops at East Wind. We've got the East Wind. It's not what we bought into. It's not the idea of what eastern Suffolk County is to me. So that's first and foremost my concern. Secondarily, I know that this meeting originally was adjourned because I guess the concern was the residents weren't appropriately informed about the first meeting, which through a letter from the Great Rock people, they said, well, in their, I guess, their own way, that they said, well, we thought that we informed everyone, we did our due diligence, we informed everyone, but okay, we'll have the adjournment. And I'm curious whether or not the Great Rock actually made any additional steps to inform the neighbors of this meeting. Because as a resident of 157 Deer Run, the only notification we saw were the two small signs, which were the same two small signs that were on our block for the first meeting. Had I, my house is not right by that sign. I just happened to drive at the end of the cul-de-sac, saw the little sign posted, informed my neighbor, who's with me tonight, and was with me the other night, that, hey, did you know that there's a meeting about the Great Rock? And she's like, no, I had no idea. She called another neighbor, no idea. So we don't feel we were informed. So I concur with my neighbor who says we need more time so we can let everyone know what the plan is, so that everyone has the same ideal of what Wading River is to us. At least let's all be informed and not just a handful of people who came today. Because not everyone knows what the Great Rock is planning. So that's my first and foremost. My second point, and I know the town attorney is helping me with this matter. There's a drainage issue, which I know is not being directly addressed today. It's not part of the site plan. But there's drainage issue. There's a lot of runoff coming from what appears to be from the Great Rock property down onto Deer Run. And it's at times, it's a river. Oh, thank you. I do have a video footage of some of the rain and some of the drainage issues that we're having on the block. I personally, again, it's not part of the site plan, it's not really part of the town, or the planning board's agenda today, but I think it's something important since we are talking about expansion plans for Great Rock, that this also be addressed. It's excessive runoff coming what appears to be from the Great Rock property. It's running down our cul-de-sac, and it's overwhelming a drainage, which happens to be in front of my property, unfortunately. But I do have, some cell phone footage if anyone cares to see the amount of water we're talking about after a rainstorm. I think that's something very important, and I want to go on the record as showing that whether or not Great Rock was aware of this problem, it is a problem. And I just kind of wanted to go on record, so thank you.
Okay, thank you for your comments. Anyone else wish to address the board? Maybe, Vic, if you could,
Mike's going to get up and we're going to respond.
yeah, I'd like to know more about the noticing, because we had recommended, because we had gotten some complaints about the noticing, and we had asked for it to be adjourned, and you complied and redid it. So to what extent was that redone, if you could, for the record?
So for the record, what was done after adjournment, the property was reposted in 5 spots, the same as it was for the first hearing. It was also published in the local newspaper. I believe it was Newsday, which was done by the town.
A second time?
A second time, that's correct. There was, per the town code, no mailing required, so a second mailing was not done. But beyond that, all of the posting and mailing requirements initially required for the hearing have been complied with. And the affidavits to that effect have been filed with the clerk.
Okay. Thank you.
Just a couple of other points
Sure.
while I'm up here. December 5th was the first time we heard about any type of drainage issues or water runoff coming on from Deer Run from Great Rock. We have Young and Young, Tom Walpert, who's here with us tonight. He's going to take a look at it. Any engineering that we can do, if in fact the runoff is coming from our property, certainly will be remedied and taken care of. And then beyond that, if there's there's anything else you would like me to address from the comments that were raised tonight. Otherwise, thank you.
Okay, thank you. So sure.
My name is Greg Bergman. I work for the Planning Department for the town of Riverhead. I just wanted to read a memo into the record, raise some questions to the applicant. As a result of continued review of the site plan application, we've identified an additional issue which needs to be brought to the board's attention, and we would like clarification from the applicant. In between the existing clubhouse and the proposed clubhouse, they're proposing a new masonry patio. The dimensions on this patio are not clearly listed on the site plan, but I roughly scaled it out, and it looks to be about 4,200 square feet. Now, there's twofold on this issue. The size of the patio was not included when calculating occupancy, nor is it included on the parking calculations for the site plan. The town has required on other site plan applications that outdoor assembly spaces be included in parking calculations. That would be Farm Country Kitchen, Grapes and Greens, and the All-Star Bowling Alley. Additionally, the presence of this outdoor patio raises the question of whether or not the proposed patio is at odds with the stipulation of settlement, which was to take these outdoor events that were happening that were causing this disturbance and therefore bring them inside. Whereby this application, the applicants are essentially wanting us to legalize and authorize, more than 4,000 square feet of outdoor space that, may pose some sort of issue. That's it.
Okay, thank you, Greg.
We had received the staff memo, obviously, at the same time you guys did today. We see that the 4,000 square foot, and we'll work with the planning department to reduce the size of it. Certainly is not the intention to have a patio outside to continue doing what we're doing now that we're representing that we're going to be doing inside. So that will be adjusted accordingly.
Okay, thank you. So I do have a question for Council Ehlers on this application. I do question in my own mind, the intent of this and the use as far as the size of it and whether or not there's going to be activities related to catering and expansion of, non-golf related uses. Some of the speakers have identified some parties that may not have been. I don't know if that's accurate or not, but the stipulation of settlement back in 2009 between the previous owner and the town of Riverhead, would it be appropriate for us to ask for a clarification from the town, being that the planning board was not involved with that settlement, and ask them to clarify the covenants that restrict the use, the non-golf related uses? Because it kind of seems like we're getting put into the middle of this, and, again, the size of it, suggests that it's going to be weddings, graduations, who knows what, and I would like, before I render my decision, to be perfectly clear on what the town meant by their stipulation of agreement.
Well, Brad Hammond's memo, I think, indicates that he, as the chief zoning officer, would like clarification as well. So you have the issue of, after your board makes a decision, before a building permit could be issued, if Mr. Hammond is not convinced that he can issue a CO, he might not give a building permit. So, and I think his memo, if you have that one in your file, indicates that he would like the town board to evaluate the use. The stipulation of settlement did not in any way disrupt the covenants. There isn't. Dewan Thomas went to great effort representing the town to make sure that the stipulation did not disrupt the covenants, and they exist the way they have existed. So any approval you give is under the control of the covenant that they cannot use it for non-golf related activities. There's always that problem, though, of where your board is caught, you're reviewing a site plan and making it conform to the dimensional requirements of the town, and anticipating a violation is always problematic. The problem is going to be the building inspector, the building department gives a certificate of occupancy that says this thing cannot be used for the uses that it apparently they want to use it for. They're just making a problem for themselves, which seems like a poor idea.
The size and scale of what they're proposing lends itself to being something contrary to what the intended use is as provided by the covenants.
Well, that's the feeling I'm getting, and that's the purpose of, the reason of my question. And why wouldn't we wait until we have clarification from the town board on what they agreed upon?
I wasn't saying you couldn't.
Okay. All right, any other questions?
If I may, to that point, a couple of items. The building inspector's memo said what's before the board today is a conforming use, first off. Secondly, as it relates to the covenants in and of themselves, there's a number of issues with them. First and foremost being they refer to town code sections that no longer exist vis-a-vis actions that were taken by the town board's own motion. Secondly, as it relates to golf-related events and things of that nature, you have to read the covenant in its totality, and you can't just pull from one item from it, because if you read it together, it's not limiting non-golf related catering events, but it's limiting it as a principal use, right? To give you an example, the golf course is 6 million square feet, right? We're talking about a expansion of 6,000 square feet. That's 1/10 of 1% of the overall use of the property. The principal use of the property is a golf club, right? What we're looking to do essentially is to expand upon our existing footprint to take an outdoor activity, which has created some terse feelings from the neighbors, and bring it inside. The size of the second floor expansion, the proposed expansion of the golf course, mimics the size of the existing patio area. So the idea is to take what we already have and just bring it inside. It's not to grab more space. It's simply to transfer from being an outdoor activity to an indoor activity.
But that doesn't answer the question of the activities that you had under the tent were permitted.
I'm sorry?
You're kind of suggesting that all you're doing is taking the events under the tent and bringing them inside, and it's going to mitigate the noise and everybody's happy because of the stipulation of settlement. But what I'm asking for clarity on is the fact of the use that you had under the tent, whether or not they were golf course related. That's the clarity that I would like for myself.
Okay.
I understand what you're saying, but it doesn't answer my
I think what
question.
you're trying to say is it's an ancillary use to golf, is that?
It's an ancillary use to golf. It's by no way a principal use, and it's the covenants that we're all harking back to about non-golf related catering, which is just limiting as a principal use on the overall property catering that's not golf related and not golf in and of itself.
Okay, thank you. Did anyone else want to speak? Just come up to the podium and state your name, please.
I have one quick question. After this.
Hi, I'm Patricia Slack. Not really sure how I feel yet about, I mean, I do want the golf course to make it. I do think it'd be great in our neighborhood. I'm on Deer Run, doesn't really affect me like it does the people on Fairfield. Honestly, I feel sorry for them. I was there before this owner, and I went to a party at the woman who spoke before, who was all for them. And when I pulled up, I didn't know they were for it. And I walked in their yard and I said, oh my God, I feel so bad for you. That music is unbelievable. You can't imagine. It's like having a wedding in your backyard every weekend. And not realizing they were for it, they got a little upset with me. So I'm going to sound like I'm a little bit on both sides today, because I kind of am. I totally hope these guys make it. My husband's a member. We love eating over at Pure. We sit outside. We enjoy, even in the winter sometimes, the light of fire. It's lovely. It's lovely for the local people. The thing I'm concerned about is hearing that you want to put an upstairs, a basement, and now a patio, and you're saying that you want to move the patio inside, which honestly, the charm of what you have is the sitting outside. It's quiet, there's no music. I've been to events that are not golf-related, I will tell you that. I've been to an event, fundraisers, it's all fundraising I'm going to, but one of them was in your tent outside, and it was loud. And it was in the winter. They had heaters, and so, you know, I feel for the neighborhood. I feel for that my neighborhood, we're pretty good. I mean, I feel sorry for the girls down there because they have the problem with the flooding. But where I
Let me ask you a
am.
question, since you don't live there, but you've gone there and heard the noise. Do you think by putting those functions, whatever they're golf-related or whatever, putting the functions indoors, do you think that will mitigate the noise and help the neighbors?
I guess what I wanted to ask and why it came up is, you're saying that it will be golf-related. I know that now, it doesn't seem like there's a lot of business over there. It doesn't seem like there's a lot of members. There's not a lot of people at the restaurant when I go. So where are all these people going to come from that are going to now warrant the upstairs? And I think I heard something about now a bigger patio. Like, that would be my concern is,
I think what I heard him say, and correct me if I'm wrong, is that they're not using the catering portion as a main use. It's an ancillary use to golf. That's what I think I heard.
but again,
If I'm
I've
wrong,
been to
correct
fundraisers that had nothing to do with golf.
Right, I think what they're saying, if I'm wrong, please correct me, that they're using that in association with the main use. Their main use is not catering. I think is that what you tried to say?
And that's just what I'm asking for clarity on.
But it seems to me they have been doing catering. So I'm then concerned, I don't want to use the word honesty, but yeah, like overreaching maybe, you know, it's going to turn into more than what's being said they're going to do. And you know, like again, I want you guys to make it. You know, you're in the neighborhood. I think it'd be wonderful. I love the golf course is beautiful. You know, I really do, and I don't know how they can make it. You know, but so there's two sides. I don't know how I feel yet, and that's why I came tonight. I just
Okay.
kind of want to hear everything and
Thank you.
see what you're going to bring to it.
When I hear all this going on about
Just your name again, please.
My name is Ray Senzak, 52 Fairway Drive. When I hear what they're saying about, a lot of these events were clearly not golf-related. And the fact of it is that someone took the time years ago to put that covenants in place. Whether you twist it, turn it, to today's standard, it was put in place to protect that neighborhood. And that is the underlining thing with that covenants. So whether you say conforming use, non-conforming use, this, that, if it's catering, it's catering. If it's a tavern, it's a bar. If it's a restaurant, it's a restaurant. That wasn't even supposed to be there in the beginning, and it was slipped in there. And most of the residents had no idea that went in there. Now, the place was resold. Now, it was resold, and nobody took any objection to them going back as they were. The problem is that the quality of life in that neighborhood will be affected if they put a 6,000 square foot place in place, and that will be the end of it. So,
Let me ask you the same question I asked the other lady. Do you think the quality of life in the neighborhood will get better before those things, whatever's there, goes indoors?
absolutely not.
No?
I think it's going to increase. They're going to increase the parking. I think there's going to be events, and it'll get out of hand after a while because they'll continue to say we can't make it as a golf course. We have to have these events, and that's what's going to happen. And it's a neighborhood. It's not like a business where you can have a discotheque and whatnot. Even now, they're going to have an event at Pure on New Year's Eve. New Year's Eve, great, okay. And somebody brought up the factor of, you know, a neighbor having a party. This is not just a neighbor. This is not just a neighbor having a one-time event. This is a commercial outfit that will have it late into the night, on weekends, when people want to relax in their homes that are surrounded by that golf course. And there will be complaints. Sooner or later, there will be. They run the stop signs. There's been accidents already coming right in front where they made the new Eastwind thing. We witnessed it, and I've witnessed 3 events in that right as that entrance is. So what's going to happen when they start bringing in, they decide, oh, well, we'll bring in limousines, we'll bring in this and that. That's where the factor's going to come into play. And, you know, I appreciate your time.
Thank you.
Adrian Hart, yeah, just make one more comment. Because we hear a lot about the covenants, and you're talking about related to golf, and you know, and it appears a couple things here that when in law they usually talk about the intent behind it when it was drafted. I don't know exactly what the intents of these covenants were, but it seems like the terms of it weren't defined well, like, because golf, the definition is a game. So when you say the principal use is golf, well, that's, you know, maybe carts, sand traps, bunkers, greens, a clubhouse, lockers, a bar, a restaurant. You know, how far are we going to stretch the word of what relates to golf? Because nobody clearly defined, at least in the terms of the covenants, what that was. So if we go back and we look at the intent of the covenant, what was the intent of it? The intent was to grant the previous owners what they wanted to do with the property, which was to have a golf course with some amenities, and limit it at that. But now we look at the intent of what the site plan is now, where we're looking at adding 18,500 square feet under roof, and the 4,000 square foot patio now. So now we're looking at, what is that, 22,000 square feet of usable space? It would appear that the intent of that is to change the business direction. You know what I mean? So if we want to look at, you know, and look at what the word related means in terms of primary use and ancillary use, catering's usually billed as a price per head. You know what I mean? Like, so if you have a 100-person party and you're charging 100, you know, $10 a head, whatever it is. Whereas golf is, you know, a round, you pay per round. You could possibly put a covenant based on, you know, add a covenant based on that might marry the two sides. We're saying that, you know, your pricing, use your pricing structure to make sure that the facility is not used as a strictly catering hall. Thank you very much.
Thank you.
Sid Bale, Wading River Civic. I have a question, maybe to get clarification on. In my notes, I don't know if I've got this correct, is correct or not. There was some mention the tent is 180 days a year? Okay. Does that mean that there is golf-related catering no more than 6 months a year? No? Okay. So with this permanent structure, we'll have catering in theory 12 months a year, right?
Well, just come up to the mic and address the board, please.
Okay. I'm sorry. Go ahead.
The 180 days is the extent to which the town of Riverhead will issue a temporary permit for a tent. That's the only reason why we have it for 180 days. If we could have it for 360 days, if we could figure out some way to do it, we would do it for 360 days, 365 days.
Excellent.
Okay, any of the member of the public want to address the board? George, did you have something, or was it answered?
It was answered.
Okay. Do you want to close it? Sure. Good. Board's pleasure on the public hearing?
Make a motion to close the public hearing for the Great Rock Clubhouse edition. So moved.
Second. Motion made and seconded to close the public hearing for the Great Rock Clubhouse Edition. All in favor? Aye. Opposed? Public hearing is closed. Okay, just to the members of the community who came out, your comments are part of the record tonight, and they will be considered by the board as we contemplate this application, as well as the applicants. Hey, Craig.
The existing clubhouse? Post clubhouse? There's a patio, right?
And it says new, okay.
Yeah, and it's significant in size.
Yeah, 'cause they have a patio out here at the end, in the winter, with it.
Yes. Well, that's where the patio is where the tent was.
Well, no, without the patio, there's a patio there for the winter.
It was just a question that was raised. If there was some, if they reduced it, but now, if you're looking at it, these are the people that would be most affected by it.
You know, the other thing is, you're adding all the.
Yeah, we're gonna get back to one sure. Okay, is there anyone from the public who wants to comment on the resolutions before we take them up? Anyone want to comment on the resolutions? Okay, number one.
Move resolution number 117 of the Riverhead Planning Board for Rock Camp Minor subdivision, which clarifies the lead agency. So moved.
Second?
Okay, motion made and seconded for resolution 117, Rock Camp Minor subdivision, issuing a negative declaration. All in favor?
Aye.
Opposed? Resolution's approved. Number two.
I'll move resolution 118, Long Island Sports Park, which classifies it as a type 1 action. So moved.
Second motion?
Motion made and seconded to approve resolution 118 for Long Island Sports Park. Classifies action as type 1. All in favor?
Aye.
Opposed? Resolution is approved. Number three.
I'll move number resolution number 19, which authorizes the clerk to publish a notice of public hearing for a site plan on Long Island Sports Park.
Second.
Okay, motion made and seconded to approve Long Island Sports Park public hearing. All in favor?
Aye.
Aye. Opposed? Resolution is approved. Number four.
Move resolution number 120 of the Riverhead Planning Board, which is a minor subdivision application for S-Power. So moved.
Second?
Okay, just one question. I see the attorney is here. There was a change that was made in the last day or so. I just want to make sure that it was all agreed upon.
Good evening, Christopher Kent, Farrell Fritz, 100 Motor Parkway, Hopog, New York. Yes, we discussed the change. I discussed it with counsel to the planning board. I also discussed it with the planning staff, and we are in agreement to increase the access from Middle Country Road to 55 feet. If that's what you're referring to.
It is, thank you.
Yes.
Very good. Okay, so we have a motion made and seconded to approve Resolution 120 for S-Power, approve the minor subdivision application. All in favor?
Aye.
Opposed? Resolution's approved.
I'll move resolution 121, Apple Honda, administrative approval of a phased amended site plan. So moved.
Second. Okay, motion made and seconded to approve Resolution 121 for amended site plan for Apple Honda. All in favor? Aye. Opposed? Resolution's adopted. Okay, anyone from the public want to address the board on any matter in front of the planning board?
Make a motion that we move the minutes of the November 16th, 2017 Planning Board meeting. So moved.
Second.
Okay, motion second to approve the minutes from November 16th. All in favor?
Aye.
Opposed? Minutes are approved. Okay, next meeting will be December 21st at 3 p.m. Okay, motion to adjourn.
So moved.
Okay, thank you.
Big question for Great Rock.
One second. Hold on.
Gotta get off the record.
Forgot, we got watching this TV show about a narc spider Ferrari. I sold in private auction, $25 million.
Yeah, I saw that.